Okay, class, chapter 1, video 12, and we're going to be talking about briefing a case. So remember I said to you earlier that when you read a case, oftentimes what you want to do is condense it into a outline type of form. This is useful for the individual who's using the case, but it's also often done for somebody you work for, like a judge or a lawyer. So oftentimes paralegals do them for lawyers, or other lawyers do them for the lead counsel on the case. So there's the IRAC form that we talked about earlier, and then there's the briefing a case. So it's a method of outlining and summarizing a case, and it serves at least two purposes. It helps the reader to understand and analyze the case better, and it provides a condensed recitation of the case so that you don't have to read the full case over again. And remember, a case could be a page or it could be 100 pages. Okay, so Appendix A has an example of a brief and the parts of a brief. The parts of a brief can vary depending on who you're briefing the case for and what they want. So there is some variance there in terms of the sections of the brief. Okay, so the form on page A1 is up here on the screen. So when you brief a case, what I suggest you do is read the opinion first, and don't think about your brief. Read it with a lot of thought and energy put into understanding the case. Then read it the second time with these elements or these parts in mind. Okay, so at the top of the brief you're usually going to put the citation and the history of the case. The history of the case meaning where it came from, what lower court did it come from, and sometimes it came all the way up from the trial court to the intermediate appellate court, now to the highest appellate court. So you recite that history. Okay, now when you are doing a brief, the most important thing I can emphasize to you, and this is something that people who like shortcuts may not do, and it usually gets you into trouble. So identify the issue first. The issue is the question of law before the court. Okay? Oftentimes the courts, in writing their opinions, are very helpful to us because they will tell us what the issue is, and it's usually in the form of a question. So for example, if we're briefing the case of Brown versus Board of Education, the issue would be whether separate but equal schools for black children and white children violate the Equal Protection Clause of the 14th Amendment. That's the issue. Okay, you write that issue down. Now remember, in almost every case you're going to look at, there's going to be more than one issue. A lot of issues in cases are going to be procedural issues or evidentiary issues. But you have to brief every single issue. So you might have issue 1, issue 2, issue 3, etc. Then you're going to do the facts of the case. Okay? Now, what you want with the facts, because most opinions are going to contain a wealth of facts, not all of which are what we call material or relevant. So something is material or relevant if it makes a difference in the outcome. So focus on your issue, focus on the outcome of the case, and look at every single fact and say, is this fact relevant? Is it material? If it's not, cross it out. If it is, then put it in your list of facts. Okay, so for example, in any given case, something could be relevant or irrelevant. Okay, if you have an automobile accident that occurred at night, it may not be relevant that it's at night. But if one of the parties didn't have their lights on their car on, it might be relevant that it was nighttime. Okay, so think about that in terms of developing your facts. Then you have your decision, and your issue should always be stated as a question, and then your decision should be a yes or no answer, and then a statement of the principle of law that the court is enunciating in a positive fashion. So you would answer the hypothetical or the Brown versus Board of Education case I gave you as yes, and then your positive statement would be, it violates the Equal Protection Clause of the 14th Amendment to have separate schools for white and black children. And that becomes your precedent and your law that has to be applied in the future. And then you go into your reasoning why the court decided that way. What did they look at? Did they look at cases, statutes? Did they look at sociological data and what's going on in the world? All those things that the court uses as reasoning. Okay. The brief can also contain a concise statement of any concurring or dissenting opinions, and that depends upon what your purpose of your brief is. But usually, at least as a dissenting opinion, it's good to have something in there about why somebody dissented. Okay. So as I said here, you want to identify the issue first and state it as a question. You want to make sure you have just the relevant facts. Again, answering the question, here's the example I gave, Brown versus Board of Education. And if you need more information about Chapter 1, and you can turn to this ULR that I have given you here.